Hai, Assalamualaikum warahmatullahi wabarakatuh. My name is Zaratul Husna binti Muhammad. My matric number is 1190841. I'm from Group KME4. So, from the 3 cases that I studied, I will explain one of them, that is MN Guha Majumdar versus Gri Denaf 1974, 2 MLG 140. Okay, let's start for the fact of cases. Basically, that the case is about the plaintiff claim include, among other things, damage for breach of contract and fraudulent misrepresentation. At the hearing, the claim for specific performance was dropped. The defendant, R.E. Denaf, advertised in the Sarawak Tribune on May 21, 1969 for the sale of his house as a property for the quick sale in order to find a home buyer as soon as feasible. 3 days later, on the 24th of May 1969, the plaintiff, along with Mr. T.O. Thomas and Mr. Reddy, called at the above-mentioned residence and inspected it, as well as the furniture and orchid. By the 2nd of June 1969, the plaintiff had returned to the aforementioned house with Mr. T.O. Thomas and Mr. Reddy. During the interval between the first visit and the second visit, a number of telephone conversations took place between the plaintiff and Mr. Reddy. The defendant illegally accepted the $70,000 offer to buy the house, orchid, and the furniture. The means of payment for the purchase price was illegally addressed during the first half of the second visit. The defendant, on the other hand, stated that he had no decided to proceed with the sale and had no accepted the mode of payment of the purchase price suggested by the plaintiff when the defendant suggested that an inventory be taken of the plaintiff's remaining furniture. During the course of the argument, plaintiff counsel maintained that a contract exists prior to 2nd June 1969. Essentially, however, the question for determination is whether in the state of fact there is a contract is existence between the plaintiff and the defendant at the material time. As it often the case, a court must select which of the two competing stories to accept based on the fact presented. In such a circumstance, a court should strive to glean what aid it can from the disputable facts, if any, that are relevant for the purpose when deciding which is more likely one. Okay, let's move on to another one, which is issue of the case. Before I explain the issue of my case, let me explain you the meaning of issue. The issue is to promulgate or send out in a lawsuit a dispute point of a law or question of fact set forth in the pleadings that is alleged by one party and denied by the other. In the law governing the transfer for distribution of property, a child, children, or any individuals who descend from a common ancestor or descendants for any degree, as applied to notes or bond of a series, data of issue means the day fixed as the start of the period for which they run. with no reference to a specific date when the bond or notes are to be sold and delivered. With regarding to bonds only, bonds are issued to the purchaser when they are delivered. Okay, when an issue of a fact arises, the court or jury must consider and evaluate the weight of the evidence in order to reach a decision. An issue of law exists, thereby providing a ground for a summary judgment sought by a party to the action when only one conclusion can be drawn by the court from the undisputed evidence, obviating the need for deliberation by a jury. The term issue is frequently found in privation of a deed. In testamentary matters, the meaning of issue is derived from the intent of the testator, a marker of a will. To intend the determine from the prevention of the will. From the case, there are three issues that happen as we can see. The first issue is the misunderstanding between plaintiff and defendant. All that happened is a quite casual conversation, whether on the telephone or otherwise. It is very much more difficult to infer that the parties are really contemplating entering into any legal relationship. The second one is plaintiff did not decide whether he wanted to buy the property because he did not take any inventory to be immediately tied up, even though the defendant already mentioned in the advertisement, which is the property for quick sale. The last one is there is no formal contract, no formal document for either parties to extend the allegation. Okay, from the issue, some decision and help had made by the judgment. As we can see, the first one is the law does not input an intention to enter into a legal connection such as that of a vendor and purchaser if the circumstance and conduct of the parties contradict such an intention. The second one is the evidence that suggested that the parties did not intend to be instantly bound. They lacked the required animus comprehendi from start to finish. Everything that happened was a discussion only. The last one is, even if an oral contract exists as a claim by the plaintiff, it was invalid in law due to a failure to comply with the prevention of the statute of frauds. That's all for me. Thank you.